about mediation. Okay, and this is specifically in civil cases. So when you start talking about domestic relations cases, and that can include divorce, that can include child custody modifications, that can include legitimation. Usually in the state of Georgia, legitimation is going to be a part of that process. And so that's what today's discussion is going to be about, kind of really describing what mediation is. In addition to that, we're going to talk a little bit about how to be successful when it comes to basically being involved in the mediation process. And hopefully, you have an attorney, you have counsel that's going to guide you through it. You don't want to enter into bad agreements, right? And then try to back out of them later. So it's always great to have counsel on your side. We'll talk a little bit though about the process, what it looks like if you have an attorney, maybe a little bit about the process. If you don't have an attorney, some red flags, things to look at, and things to think about. Okay. So again, I don't know if I did the introduction. Genghis Shakan. I'm the managing attorney here at Shakan and Wilkerson Law Firm. I'm here on behalf of myself and my lovely partner, attorney Chelsea Wilkerson. We're a boutique law firm located here in the state of Georgia, and we cover everything from essentially family law, divorce, men's rights, legitimations, and criminal defense, right? So we handle both misdemeanors as well as felonies. And so we are almost a one-stop shop. Of course, if you know anything about the law, you know that we are pretty much, if you're involved in law, any kind of people activity, more than likely, you're going to find that there are attorneys involved in really settling disputes and things of that nature. So we only focus on criminal and family and domestic relations matters. Okay. All right. Now that being said, we are going to do a deep dive into, as I mentioned, we're going to talk a little bit about mediation here in the state of Georgia, which is for the most part mandated. If you're going through a domestic relations case, you're going to find that some judges won't even talk to you. If you have not mediated, they will not schedule a hearing, right? Depending on which jurisdictions we're talking about. But there are some, especially in the Metro Atlanta area, where if you have not talked in mediation, they will not even let the parties be heard. Okay, so if you're going through a divorce case, custody case, legitimation case here in the state of Georgia, there's a good chance that you're going to go through that mediation process. And what I'm going to do is break down that process. As I mentioned, I gave you a really quick roadmap, and this is I'm essentially going to share with you what today's topic is going to be on. Is we're going to talk mediation. I'm going to define it, describe it, talk a little bit about how it can be advantageous to the parties to engage in it, and then from there we'll talk about the pros and cons, and then how to be successful. Again, we'll mention a few red flags, and then we'll wrap up. Okay. All right. So pretty simple stuff. Mediation is actually a good thing. Okay. It is a way to settle disputes outside of court, right? So everything doesn't have to be overly litigious and adversarial. Sometimes people can come together, and they can come to agreements and terms on their own. The great majority of cases are actually settled outside of court. People don't really understand nor recognize that, right? A lot of cases don't make it to a judge's trial calendar or a jury trial. Okay, they are settled outside of court. So that is essentially the definition of a mediation. It is trying to settle your case without a trial, and sometimes that's possible if the issues aren't too complex. If there aren't, like for example in a divorce, if there aren't too many assets, if you're not locked in a zero sum game, so if both parties aren't fighting for primary custodialship of the minor children, if there are agreements that can be had, then sometimes negotiation can actually work, and sometimes it's actually disadvantageous to go into mediation and settle, and it might actually harm your interests. And so that's why it's always great to have an attorney that's going to look over any kind of settlement agreement or that's going to help you in the mediation process, so you know whether or not you're getting into a bad deal. Because sometimes just because you want to expedite, the process, you don't want to enter into a bad agreement and have buyer's remorse. And a lot of times we get those calls. Folks realize, oh, this is a terrible agreement. I probably should have had someone look over these terms that I agreed to because they're horrible and unconscionable. But sometimes it's hard to undo those things once you do them. So you got to be careful trying to save a few bucks. You'll make some bad decisions that will haunt you for years, right? And they can be bad financial decisions. Okay. All right. So who is going to be present at that mediation? Let's start with that. Obviously, you're going to be there. The opposing party is going to be there. And then, if there are lawyers involved, lawyers will be there. And then there will be a neutral party, and that's going to be the mediator. Mediator is not supposed to have a dog in the fight, right? They are an impartial party. They don't know either party. And I will also add this: a lot of mediations these days, especially post COVID, have been virtual. Okay, so you will have some mediations in person. However, the vast majority of the mediations that we work these days, they are virtual. Okay, so you can anticipate showing up virtually. Either you're going to be at your attorney's office, or you're going to be on your own device, and then of course you and your attorney will go into breakout rooms. The mediator, they're pretty good at facilitating the technology to put you in your breakout room with your attorney or with your counsel. Okay, and the same will go for the opposing side. All right. Sometimes it's easier to come to an agreement in terms in that type of situation, as opposed to I've done mediations where everybody is in the one big room. And those are tough. Okay, those are tough for all of the reasons you suspect that it's tough, right? Is you know um, being face to face with someone that you might loathe, right? It can be a little challenging to get through the fog of your anger, and all of the emotional backlash that might come with that. Okay. And so sometimes those virtual setups, in my opinion, are probably the most productive. Okay. So those are going to be the parties that are going to be present. You, the opposing side, opposing side's counsel, your counsel, if you're both represented, or even if you're not represented, and then the mediator. Okay. And so the mediator is, and sometimes people make this mistake. The mediator is not the judge. The mediator could be a retired judge, right? But for the most part, mediators, they might be attorneys. Sometimes they are attorneys. Sometimes they are retired judges, or tired professionals, retired professionals. And then sometimes they may have a degree in something altogether different, right? So mediators can basically just be certified mediators. But sometimes people are under the impression that we try to disabuse them of this notion that the mediator, at least our clients, the mediator is going to be the judge in their case, and they're listening to the parties' sides prior to hearing them inside of the courtroom. And so we try to articulate to our clients, listen, this person is not the judge. Okay. So we don't have to make our best arguments here. Here we're trying to see if we can settle. Okay, see if there's a settlement that can be had and made between the parties. So important to note that. All right, so just keep that in mind. So mediation usually is required. Usually we like to mediate on the backside of discovery. We like to, for the reasons, all the reasons that make sense, right? You want to look at all the documents, especially the financial disclosures, before you're entering into an agreement, right? If you do that before you enter into an agreement, you may find that there are some hidden assets out there, but you've already come to terms, and so it makes sense to look at all these documents before you jump right into mediation. Sometimes people want to facilitate this process and move it and speed it along, but you have to do this thing correctly so that at the end of this, you're not trying to motion for a new trial, or for reconsideration, because it came out that there were other documents, or financial information that wasn't disclosed, other assets. So very, very important. We like to get all that stuff in before we sit down to mediation. All right, now why mediation, right? Why is mediation important? Why even do it? Some people are upset that it has to go through mediation before they can kind of move on to get in front of a judge. And it's for many reasons, right? One of the reasons is because there's in many jurisdictions, there's a backlog of cases, right? Some of these cases, every case does not have to be heard. Some of these cases can be resolved outside of the courtroom. Some of the parties are pretty close, right? They're not that far away, and so a resolution might be on the horizon for these guys, right? And so in that instance, they may not need a actual judge or go into a courtroom, and so mediation can be helpful. It also encourages settlement. Okay, so it encourages the parties to settle, right? And that can be a good thing, right? If again you're not that far away, or maybe the parties don't have a lot of assets, right? Maybe there are no children involved, so maybe you don't really have a complex divorce, and there's no reason for you to have to go stand before a judge and get your issues addressed. They can happen in court. And then lastly, it just saves time and money, right? If you can come to some kind of terms and an agreement before court, then guess what? You're going to save yourself maybe tens of thousands of dollars. That might work if you have, again, a very basic case. You guys don't have a lot of assets. You guys haven't been married very long. You guys don't have any children, right? That might be a best case scenario for you to come to some kind of agreement outside of court, right? Because your matter is just not that complex. So courts want to resolve these cases, and whether that's going to be in front of a judge or outside the court, and they want to resolve it, before a trial if that can happen. And so mediation is strongly, strongly encouraged. Okay. Now let's talk about the mediation success rates. Okay. And it depends, right? And then also you have to think about the metrics for success. What are we calling success, right? A lot of times, we'll hear some mediators say, it's a good agreement if both parties, kind of leave the agreement unhappy, right? I don't know how true that is, but I would say, at least in my experience, we've probably had less than 50% hovering around that area success rate when it comes to mediation. Sometimes you can reach partial agreements, right? Again, and sometimes it behooves you to go into a partial agreement. Maybe let's say regarding the custody, right? Maybe one party knows that they are going to be the primary, and the other is already, like, hey, I'm going to be the non-custodial parent. Let's just talk about the parenting plan and let's come to an agreement on a temporary basis just regarding the kids in custody, right? And so sometimes people will do that. Sometimes it's not in your best interest to come to a partial agreement. For example, things like the house or retirement or certain assets being disposed of before you get to court, simply because when it comes to negotiations, some of those things are going to be bargaining chips, right? And so if you are giving away your tokens in a possible later on negotiation, it puts you in a weak position, to be able to again negotiate from a position of strength. Usually that's what is going to be more successful. You're going to be more successful at it if you are negotiating from a position of strength as opposed to a position of weakness. Okay. All right. Now, so just keep in mind though, regarding a lot of these family law cases, many of them they do settle. Okay. But some again are more basic. The complex cases, those high conflict cases, sometimes those don't settle, right? Sometimes those are going to absolutely 1000% have to be heard by a judge, all right? So, mediation, I do want you to kind of have this takeaway. Mediation is successful and it can be successful, and the parties can be successful going through the mediation process if they come into the process serious, and then if they come into the process with an open mind and open heart, that maybe an agreement can be reached. And they really have to take into consideration what their legal goals are. But if they come in there very emotional, if they come in expecting to wreak havoc, if they come in wanting a pound of flesh from the opposing side, then you may not have that high degree of success. So here is again some of the benefits of mediation and why people choose it. One is this going to be a lower cost? Two is going to be a faster resolution. You're going to get a little more privacy, right? So those are closed sessions, not open to the public. So it's just you and the opposing side, as well as their counsel and the mediator in there. So there is no transcript of the mediation. And then you're going to have more control, obviously, over the outcome. If you settle in mediation, you control the outcome. If you don't, then that means the judge or a jury controls the outcome. And then lastly, it's just going to be less stressful, right? Going through court, litigating, obviously highly stressful stuff. And it can be, fairly costly as well, financially, as well as the emotional toll that it takes. All right. So, another benefit is that a trial can take months. A trial can take years, depending on, again, how complex the issue is, and then or issues plural, and then of course the jurisdiction, how busy the docket is, how efficient the jurisdiction is on moving cases. All of those things come into consideration about how long it might take for you to actually stand before a judge. So mediation can really resolve most of the issues just in one sitting, right? And so, mediation, I've sat in mediations that are 8, 9 hours long. And you come out of those sessions with an agreement on all terms, right? That can happen. Or again, you might reach a partial agreement, all right? So settlement gives families control, all right? And so that's something that you need to really think about and take into consideration as you're going through this process. And these are the things that the mediation and the mediator do not do. Okay, the mediator does not represent your interest, right? And so be very careful sharing long drawn out perspectives and stories and disclosing evidence, especially if the mediator is going to share that with the other side. It might put you in a very precarious position, and sometimes it can actually harm your interest. Most mediators will not give you legal advice. They really shouldn't, and especially if they're not attorneys. But that's the other side of it. If a mediator is not an attorney, or even if they are an attorney, they're not. If it's a family law matter, not a family law an attorney, then it might be bad advice, right? And then it can ultimately hurt your interest again going forward if you don't reach an agreement, or even if you do. And mediators generally will not force you to settle. Okay, so they won't force it on you. So that's important. You can settle, or you can walk away from the table. You do not have to go into mediation and walk out with an agreement. Sometimes people are under the impression that, hey, we have to reach an agreement today, and that's just not the case. You do not have to go into that mediation session and come out with an agreement. Okay. All right. So the mediator job is to help simply move the negotiations forward. That's it. Real simple stuff. Now, here are some of the common issues that are going to be discussed in mediations, especially when you start talking about domestic relations cases. Obviously, we talked about one is going to be divorce. Custody can be discussed. The mediation, usually the divorce part is really agreed upon. If you're going in there, say, hey, we're going in here to get divorced, that's usually the easiest thing to accomplish, right? It's usually it's irreconcilable differences, and no one is going to have a problem with severing your union. It's all the other residual stuff that comes with the divorce that you will discuss in the mediation. So custody, parenting plan, child support, all the usual suspects, alimony, property division, debt division, all of that is going to be covered in that mediation session. And if you come to terms again and settle, that means you're going to settle on all of those terms if all of those things are part of your case. All right. So and so most people, those are the issues that are going to be shaping the future of a divorce trial, or a custody trial, if they do move forward and are unsuccessful in mediation. So here's how to prepare for mediation. You want to have your financial documents and records. Be careful again sharing that stuff with the mediator, and or forwarding it to the other side, unless they are just disclosures that are supposed to happen. Usually mediation is not the place for exchanging discovery, right? That things discovery should happen outside of mediation, should happen before mediation. At least that's something that we like to do, right? So you can bring financial documents. You can have in mind what you'd like a parenting schedule to look like. the parenting plan, kind of questions that you have, and then you want to think about your settlement goals, right? So what are some things that you might be willing, to forego in order to reach your legal goals, okay? What might you settle on or be amenable to settling, regarding? And what are some of your hard no's? What things will you absolutely, where will you draw your line in the sand? And that's something else that you should kind of think about. Okay, so knowing your priorities, and then lastly knowing your non-negotiables, and then what you are willing to compromise on. Okay, now let's talk about the biggest mistakes that we see folks make when it comes to mediation. Here's some pretty common mistakes: is they let their emotions and kind of control the negotiations. Okay, so folks will try to start diving into the weeds. They'll talk about whose fault the divorce is, and they'll try to really talk about maybe the history of the relationship, and then things that are basically not relevant to litigation and relevant to the negotiations, right? So that's a big mistake. One, is time consuming. Two, all it does is just emotionally charge everyone, and then it just makes the mediation session unproductive. Okay, and so you want to be careful with that. Walking in unprepared is another, and then hiding assets, right? So sometimes people go into these things, they're hiding assets. And it becomes very challenging to settle a case where the opposing side, especially the opposing side, knows that assets are being hidden, right? And so if they or they suspect that assets are being hidden, and all that's going to do is prolong the divorce, prolong litigation, and mediation will likely be unsuccessful, because they won't come to terms where folks know that, hey, there's probably some assets that are missing and that are being hidden, right? The other is just refusing a reasonable compromise. And sometimes if because people, how they feel emotionally, they're just unwilling to compromise, right? And if that happens, then that makes settling that much more challenging. Even if there's a reasonable offer on the table, people are not willing to entertain it. It can be a very, very long afternoon. And then lastly, treating mediation like a fight. It is not a battle royale. It is not a super weight bout. You are there to see if an agreement can be reached. If it's going to be combative, then essentially basically it needs to just basically say, hey, both parties cannot come to terms, and then we'll just have to battle this out, duke it out in the courtroom. All right, so here's how attorneys can help you in the mediation process. When offers do surface, the attorneys can evaluate the offers, and it's important to know that even if it doesn't work out in mediation, if there's an offer on the table, you can still come to terms before you actually make it to trial, and your attorney can advise you on that, right? And then they're there to protect your rights, okay? And they go protect your rights by telling you, hey man, this offer that's on the table, this is a bad deal. Like, there is no way you should enter into this agreement. Many times people just, because you are in it and you are so, really emotionally compromised, people can't think 2 years down the road. And that's where your counsel really earns their keep. And they can say, hey, listen, I understand that this deal looks attractive today, but you're not going to feel that way 3 months from now, or you're not going to feel that way when your spouse, soon to be ex, takes on a new romantic partner. You're going to feel a little differently, okay? And so that's the importance of having counsel. There is, they are a party that should be they should be emotional. They should have some distance from the case, right? They're not as emotionally vested in the case as you are. All right, and so that is the benefit of having an attorney. All right, so they're going to spot unfair terms, address hidden assets if they have concerns about them, and then negotiate some parenting plans. I apologize, I have a lot of light coming in here, natural light, so I'm not mad at it. It feels wonderful. But I understand it might be cast some shadows when it comes to the filming. So all right. Now, another important thing to keep in mind is a bad agreement how it will affect you. It will affect your finances. It can affect your custody rights, and it can just be a problem for you in the future in years to come. So an attorney is really going to be beneficial to use when it comes to when it talks about mediation and going through the mediation process. One of the things they can really address is the custody and the parenting plans. This is again where attorneys earn their keep because a lot of parents just aren't familiar with what a good parenting plan should look like, right? Holiday schedules, transportation, decision making authority, and all the communication rules. All of that stuff is inside of a parenting plan. And if you just don't have the experience in drafting and working parenting plans and understanding how a judge might rule when it comes to parenting plans, then all of that stuff might come back to bite you if you enter into an agreement, especially if you're pro se and the other side is represented by the counsel. You might get taken advantage of, right? And so the parenting plan is something that you do want to be very, very mindful of when you're if you have a custody matter, even if it's tethered to your divorce and you are unrepresented, but the other side is represented. Then the other thing is going to be the financial issues and hidden assets. Okay. If you're unrepresented and your spouse is hiding assets, or the other side has an attorney, and you're not real clear on whether or not they've submitted all the financial disclosures, or if they were even accurate, or you haven't had an opportunity to look at it, or you didn't even know what to ask for in the discovery process, there could be some potential issues, right? And so here's some red flags. There's some missing financial documents. Maybe there's secretive financing or finances regarding offshore bank accounts, cryptocurrency stuff, located in safe deposit boxes, or businesses that you were unaware of. All of that stuff is things that you want to be mindful of especially if you are unrepresented. If you're represented, your attorney should go digging and go looking for those things. Okay. Now, so attorneys will obviously they'll use the discovery process. I talked about that. They'll look at those bank records. They look at the domestic relations financial affidavit. They do all of their homework before that mediation usually, and so they come into the mediation with all of the firepower, all of the ammo, understanding what needs to happen to get you the best deal. If you are pro se in those proceedings, then again, you might want to do a little homework prior to going through that process. Okay. Now, mediation may not work well in situations where there has been domestic violence. Matter of fact, that's one of the questions that the mediators usually will ask about. If folks are just pathological liars, they are just very dishonest about things. People who refuse to negotiate. If there are hidden assets, or the parties just kind of have these high conflict personalities, right? That's when mediation may not be successful and work out for the parties. Okay, then let's talk really quickly as we begin wrapping up. Mediation versus a trial. The mediation is private, it's flexible, and again, it is faster. A trial is public. It can be costly if there are attorneys involved, and then the judge is the party that decides the outcome, right? Or a jury, right? If we're talking about the division of the marital estate, the judge is going to be involved if there are children involved. He has to consider he or she has to consider the best interest of the child. Okay. All right. So, quick roadmap regarding mediation. Your case is filed. You go through the discovery process. I told you about that. The mediation is scheduled. You guys negotiate. Maybe a settlement is had. No settlement, you're off to trial. Okay. Now, if you are going through mediation, if you are in basically a custody fight, or going through a divorce, or you need to get legitimized, give our office a call. We can help you out if you need representation. Right. My name is Genghis Shakan of Shakan and Wilkerson Law Firm. 478-845-1213 or 404-999-9529. We'd love to help you out. If this video has been helpful, give us a like. Also, give us a follow. If you know someone that needs this information, they're going through this very situation that I've described, make sure that you share. Make sure you follow the channel, guys. Make sure you encourage others to follow that might be having legal issues, whether they are family law related, divorce related, or criminal defense related, we can help. All right, guys, thank you for joining us. We'll see you next time.